Welcome to Immaculate Reflections' first Discrimination, Harassment, and Employment Law seminar. At Immaculate Reflections, we share a common belief that each of us should be able to work in an environment free of discrimination and harassment. The objective of this seminar is to make sure that you understand what harassment is, that you know how to deal with it, that you learn that it may be unlawful, that you understand that it will never be tolerated by Immaculate Reflection, and that you know how to make complaints. Immaculate Reflections has had a policy in its manual for years that forbids harassment, and we've taken steps in the past to educate you. We're going to take a few minutes now and test you to see if you're able to answer the following question. Sexual harassment in the workplace is a form of workplace discrimination. True or false? The answer is true. Any Immaculate Reflections employee who engages in or knowingly condones harassment, including sexual harassment that is related to employment, is subject to disciplinary action up to and including dismissal. True or false? The answer is true. If your intentions are good, your behavior can't be considered sexual harassment. True or false? The answer is false. If everyone else is okay with a worker's behavior, you should just accept it, even if it offends you. True or false? The answer is false. Asking a coworker for a date is not sexual harassment. True or false? The answer is true. Asking a coworker repeatedly for a date after he or she has told you that the behavior is unwanted is not sexual harassment. True or false? False. If you ignore the behavior of sexual harassment, it will ultimately stop or go away. True or false? The answer is false. Sexual harassment must be dealt with immediately. It is not important to tell someone to stop unwanted behavior because it usually doesn't do any good. True or false? The answer to that is false. All employees share responsibility for ensuring that the workplace is free from all forms of harassment. True or false? The answer is true. Sexual harassment is only prohibited if it occurs in the workplace during working hours. True or false? The answer is false. Immaculate Reflections prohibits any form of retaliation against an employee who complains of sexual harassment or who cooperates in the investigation of a sexual harassment complaint. True or false? The answer is true. We're now going to discuss some important definitions that you need to know in order to understand the full gambit of sexual harassment law. It's important to understand that harassment standing alone is not unlawful. In order for it to be unlawful, harassment has to be based on a protected characteristic. On your screen, you can see the various characteristics that are protected by state, federal, and local law. The primary area of harassment that results in litigation is sexual harassment. Our policy is to forbid any sexual harassment in the workplace, nor will Immaculate Reflection tolerate adverse treatment of employees who've reported harassment or provided information related to complaints. That is called retaliation. This prohibition covers harassment by anyone in the workplace, including supervisors, co-workers, non-employees such as customers, vendors, and outside agents. Sexual harassment involves unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct or communication of a sexual nature when submission to such conduct or communication is made a term or condition of employment, or when submission to or rejection of such conduct or communication is used as a basis in decisions affecting such individuals' employment, otherwise known as quid pro quo harassment, or when such conduct or communication has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Immaculate Reflections will not permit any situation where an employee's submission to or rejection of harassment or discrimination is used as a basis for employment decisions, nor will we allow any situation where harassment or discrimination has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. We will not tolerate or condone harassment or discrimination of our employees by their supervisors, by their coworkers, or by third parties on our premises over whom we have control. Our policy against harassment and discrimination applies to all areas of employment, from recruitment and hiring through training and promotion, compensation, benefits, transfers, and social and recreational programs. Any violation of our policy will subject the violator to immediate disciplinary action up to and including suspension or termination. In 1999, the U.S. Supreme Court decided a case called Farragher versus Boca Raton. In its decision, the Supreme Court laid out standards that an employer could follow and by following them be immune from claims for sexual harassment. Subsequent decisions by other courts extended that same immunity to harassment claims based on other protected categories such as race or national origin or age. What the Supreme Court said is if employers establish a policy against harassment and discrimination and disseminate that policy to their employees and train their employees and management about harassment, and if a claim or complaint is made, investigate it promptly and take appropriate action to make it stop, that would insulate an employer from liability for sexual harassment. We're now going to discuss hostile work environment harassment. Courts have defined harassment based on sex as conduct that is unwelcome, as is indicated by the photos on your screen. To constitute sexual harassment, the conduct must not just be unwelcome, it must be offensive based on a reasonable standard. What we've displayed on the screen are two visual graphics. One of them, people could agree or disagree on whether it's offensive, but we don't think any reasonable person is going to dispute that the bottom photograph displays an offensive message. In addition to being unwelcome and offensive, harassment must be based on protected status in order to be unlawful. That means one of those various laws and categories that I showed you on a previous screen that are protected by law from discrimination. Lastly, in order for the conduct to constitute harassment, it must be severe and pervasive. As you can see, there is no photograph that depicts that, nor is there a definition that is sufficient. Severe and pervasive means conduct that occurs not in isolation and which a reasonable person would find to be offensive. It should be important to note at this juncture that conduct can be a violation of Immaculate Reflections policy, but not be unlawful harassment. Nevertheless, Immaculate Reflections would treat it as if it is. It's important for you to be aware about how your conduct impacts others. I'm going to give you some helpful hints to avoid being charged with sexual harassment by your coworkers. Ask yourself the following questions. Would I behave the same way or say this in front of my grandmother, my spouse, my parent, or my child? Would I want someone else to act this way toward my grandmother, spouse, parent, or child? Could my behavior be sending out signals that invite harassing behavior on the part of others? If it's not about business, it's none of your business. Why does it need to be said at all? Keep your hands to yourself. Don't talk about sex on the job. Never mix a discussion of social life with a job-related counseling session, particularly if you're discussing a disciplinary procedure or a possible upgrade, promotion, or hire. Keep your compliments casual and fairly impersonal. Avoid jokes, words, phrases, and gestures with sexual meanings, and respect the person's personal space. An important part of Immaculate Reflections policy is its reporting procedure. If you feel that you're being harassed based on any of the protected characteristics that we've discussed, we recommend that you tell the person who you believe is harassing you that they're offending you. This can be done in a tactful way. However, our policy does not require you to do that. If you're uncomfortable for any reason confronting the person who's made you uncomfortable, our policy provides a clear direction on what you should do. Contact Lisette Duran. On the screen is a list of responsibilities that a supervisor has to assure a workplace free of harassment. The Human Resources Department has a key role in preventing sexual harassment. That's who you report any complaints you have about sexual harassment to. If a complaint is made to Human Resources, it will always be taken seriously. It will be investigated promptly. Interviews will be conducted to gather information. Any findings that the Human Resources Department makes will be based on fact. Action will be taken to stop the harassment if it's determined that it has occurred, and we will respect the confidentiality of the process as much as is possible. In summary, people want a work environment where they're treated with respect, where they're treated fairly, and where they feel safe. Immaculate Reflection has taken all steps it can to provide that environment. Immaculate Reflections shares a common belief that each of us should be able to work in an environment free of discrimination and harassment. Immaculate Reflections policy against discrimination, retaliation, and harassment is contained in the employee manual which you have been provided. This and the next two screens after it are a copy of that policy. I want to call your attention to the most important aspect of that policy, which is that if you have a complaint, you need to bring it to the attention of Lisette Duran in writing as soon as possible. To change this subject, we're going to talk about the business model that has been successful for Immaculate Reflection for decades. We're in the contract procurement business in the cleaning industry. While we're procuring contracts for the cleaning industry, we are not in the cleaning business. Rather, we obtain contracts with restaurants and hotels. We then find them professional, qualified subcontractors. We do not clean restaurants through our employees except in a bona fide emergency. Our independent contractors and their employees clean the restaurants and hotels with whom we have contracts. Why the distinction? Because we've successfully built our business based upon this model and have created thousands of good jobs for our contractors and their employees. Because we help entrepreneurs build their business. What is the distinction between independent contractor and employee? Well, there's several factors that are important. Independent contractors control how they do their job, whereas employees are told how to do their job by their employer. Independent contractors provide their own equipment, whereas employees are provided equipment by their employer. Independent contractors can make more revenue, but they can also lose more. Independent contractors are rewarded for their efficient management of their workers, not for cleaning the restaurants. With independent contractors, we can focus on getting more contracts and evaluating the quality of the work product of our existing contractors. Independent contractors can turn down or negotiate any contract we offer them. It's important in the future to document that fact. Independent contractors are free agents. They can perform cleaning services for customers other than Immaculate Reflections customers. The difference between an independent contractor and employee is sometimes blurry, but we hope that this presentation will clear that up for you. We have to be careful in the use of language to avoid the confusion. We should never refer to a contractor or the contractor's employees as being one of our employees. It's important to note that while we're concerned about the final product being an appropriately cleaned restaurant or hotel, our choice of business model precludes us from exercising control over the manner in which a contractor's work is performed. Our primary interest is that the contractor and its employees' finished service product meets the standards of the customers. In the law, words can make a difference. For instance, we don't train our subcontractors' employees. Their employers do that. We provide orientations or demonstrations. When a new contractor joins us, we want to make sure the contractor and its employees understand the customer's specifications in the contract. Explaining or demonstrating those specifications is fine, but it's not our job to train our contractors' employees, nor is it our job to supervise them. That is how the contractor earns their money. Under the law, actions make an even bigger difference than words. Quality control liaisons and supervisors should never clean a restaurant, except in a bona fide emergency, but they can give a demonstration of how it's done. Quality control liaisons and supervisors can be a resource to their contractors, but they should never be a crutch. Quality control liaisons manage a large territory and are not controlling one account on a regular basis. Thank you for giving me the opportunity to make this presentation to the employees of Immaculate Reflections.